Welcome to the Probate Nation. My name is Richard Ruddy and I am the host of the show this evening. In prior shows, we have covered the importance of adults executing certain legal documents such as durable powers of attorney and advanced healthcare directives, so that should they become incapacitated, someone is able to make legal and medical decisions for you. Good documents to have, and with them, your family very likely will be able to avoid the need to obtain a court-appointed guardian or conservator. But there is a group of children with special needs that cannot execute such documents when they become an adult at the age of 18. These often include children with autism, Down syndrome, dyslexia, and ADHD. Regardless of the nature of their special need, however, parents are faced with the need to obtain legal guardianship of their young adult child for a host of reasons, including medical decision-making, education decisions, and in time housing and employment decisions. Absent such authority, the parents will be without the legal ability to manage all this for the benefit of their adult special needs child. Over the course of 2 shows, we will look at the process that parents need to initiate and complete to be appointed the legal guardian of their adult or soon-to-be adult child. We will cover the petition to be filed, the investigation and report of the guardian ad litem appointed by the court, and the rights of your adult child in the course of that legal process. In addition, we will also discuss the hearing itself and what should be included in the court order entered at that hearing. And finally, we will touch on some common problems and pitfalls that often arise along the way. With us tonight are 2 elder law attorneys to guide us in this discussion. Our first guest is a principal with the law firm of McCandless-Lillard with offices in Fairfax and Leesburg. She has been practicing law for over 20 years and has extensive experience in the areas of guardianship, conservatorship, and special needs planning. She's a member of the Special Needs Alliance, an invitation-only group of disability and public benefits attorneys. She has been recognized as a top attorney by Super Lawyers and Washington Magazine and is ranked as one of the top 50 female lawyers in Virginia. Our second guest is a partner with the law firm of Dingman Labowitz PC in Alexandria. He focuses his practice on guardianship, conservatorship, estate administration, and contested fiduciary matters. He also serves as a guardian ad litem for incapacitated adults. He has comprehensive litigation experience in state and federal courts, now primarily focused on elder law matters. He has been recognized as well as a top elder law attorney by Super Lawyers and Washingtonian Magazine since 2009. Please join me in welcoming attorney Liz Gray and Ken Labowitz. Geez, you guys are awful talented. Wow. Well, thanks for coming by to have a conversation about this really, really important topic.
Nice to be here.
Yes. Liz, the first topic is really decision-making by a minor child. So, if a child's under the age of 18, they're often referred to as being a minor. But what legally binding decisions can a minor actually undertake when they're under the age of 18?
None. Only the parent or the guardian can make decisions with respect to a child's health and finances.
Okay. And so as far as education is concerned, during that time period, they're the ones that actually will be able to deal with the schools as far as managing their educational development as well?
That's correct.
Okay.
The IEP, Individualized Education Plan, the parent is always in on that meeting.
Okay, that's important. So what is, when we use the expression, though, certain children have special needs, what does that mean? Because that seems to be a very kind of an amorphous term.
Yeah, it does. It's really somebody with a physical, emotional, or learning disability type of condition that requires special services or accommodations for the child.
Okay, okay. Can the parents of a special needs child make their health and financial decisions for them while they are a minor child?
Yes, absolutely.
So that's the key, now while they're under the age of 18. So Ken, as we work that process forward, the minor child ages up, they all grow and get older.
Right. Well, it's a binary system. If you're 17, the parent is making decisions for you. As soon as you're 18, that world changes.
And that's really a challenge at that point. Right. So at that point, then, they cannot make legally binding decisions.
The parents can't. The child can. And all things change dramatically so that, for example, where Liz and I get involved, the school system will no longer speak to the parent, just won't talk to them. because there's the parent of an 18-year-old is essentially a stranger to that child, legally a stranger. Your child is a stranger to you exactly the way I'm a stranger to your child, which is an odd concept, but the actual reality. So that if the rules are being followed strictly, the doctor won't talk to the parent. You go from the day before, when the child is still 17, well, of course the doctor is going to talk to the parent. Of course the school is going to talk to the parent. And then on the 18th birthday, all that changes.
And that's really, and if a child does not have the ability to make those decisions for themselves, they're in basically no man's land for a period of time.
Well, it is scary. And to some parents, it is a complete surprise. Well, I've always been responsible. I've always made decisions for my child because he or she needs me to make that decision. Well, maybe still, but we've crossed the line. So the child is now 18, and there's no automatic involvement of the parent with the child.
Okay. Well, Liz, so what can a parent do in order to retain authority to make decisions for this child as they turn 18?
Well, there are two choices. They can have the child do a power of attorney or an advanced medical directive, and then the other choice is a guardianship. I think that the thing that people don't realize with a power of attorney is that it's concurrent. So if I sign a power of attorney, it doesn't mean I can't act. I can still act and sign contracts, where a guardianship takes away that right.
Mm-hmm. And of course, we have to figure out whether or not that child actually has the capacity to actually enter into that contract and grant those powers.
Exactly.
That's one of those challenges. Sure. So when should the petition, I mean, I guess the process to go to court is you file a petition seeking guardianship. When should a parent actually undertake to file that petition?
Well, Virginia law allows you to file a petition 6 months before the child will turn 18. I get a lot of clients that come in, the parents know that the IEP meeting, the last IEP meeting will happen once the child's 18. So they want to get that guardianship done ahead of time so that they can attend the meeting.
Okay. Okay. So that once we hit that 6-month clock, it's starting to tick. We need to get on the ball and get moving. So again, I can mention that when the child does turn 18, the schools start to be resistant to having conversations with mom and dad.
They shut the door.
They do.
And because to the school system, they're now dealing with an adult. And chronologically, everybody's an adult at 18. We don't have gradations of adult. There are certainly some 18-year-olds, frankly, there's some 50-year-olds who can't manage for themselves and need the help of someone else to make decisions with them.
Sure.
And that's what the guardianship process is all about. And getting a substitute appointed so that there is continuity, that there is a person ready to make decisions, because decisions need to be made. And at the same time, a person who's not able to make good decisions for themselves should be protected, so that, for example, one of the things that happens with the guardianship is that automatically the person who's under the guardianship loses the right to get married, for example. They can get married, but they have to have a judge approve it, so that the parent or the guardian can be reassured that there's not some impulse that this child decides, I need to get married now, and certainly there are such people. There is some protection.
And that's important. So I think we're gonna. Those are some of the things we probably would address if we know in advance. May address those in the final order. Let's talk a little bit about, Ken, the actual petition for guardianship, which again we want to start to write that up.
Right.
As the 6-month period opens. So.
Right.
Talk about what are some of the most important components. What's the most important component of a petition?
The most important component is that while this is a legal proceeding, a doctor or a medically licensed person, which means not just a physician, but a nurse practitioner, a licensed clinical social worker, a psychologist, there is a list of professionals who can sign a report that says, I have examined this individual, meaning in this case the child, and as a result of a diagnosed condition, the child is not able to make medical decisions or care to make the decisions that are essential to his care, and therefore a guardian needs to be appointed. I may not be making any friends here, but doctors are very difficult to deal with. I
They
think
don't like to hear from lawyers.
they do not like. There is no group in America who likes lawyers less than doctors, and there's a different time frame of reference. So that when I speak to a doctor, typically not to a doctor, but to an assistant, and I say, I'd really like to have this soon, or as early as possible, or at the doctor's earliest convenience. Somehow the doctor doesn't hear that as now. The doctor hears that as being at some point in the future. So I have stopped relying on doctors' promises. I need to have the doctor's report, which does not have to be complicated. I've examined the individual, the person has a diagnosed condition, and as a result of the diagnosed condition, the person needs a guardian. I just dictated it to you. I have to have the doctor's report in hand because I've had promises that have not been kept. And there's nothing I can say that generates that report promptly if the doctor isn't of a mind to do that.
And certainly if the parents know that they can't get the process moving
Right.
until you have that in hand,
Yes.
that they're the best people to actually get on the phone
absolutely.
and actually move that ball.
Right. You know, as you would be in your own practice, some stranger calling up, particularly a stranger who is a lawyer, is a provocative act. Well, I don't mean it to be provocative. I mean it to be helpful. But it's not heard that way all the time.
Sure.
And so I need this piece of paper. I don't need the original to go with it. We've now moved to copies and faxes and scans are okay. But it needs to be from the doctor, from a medical professional rather. I am making the mistake I want to avoid. It doesn't have to be a doctor. It has to be somebody who's properly licensed to make that determination. I need that in hand. And once I have that, I can put together the petition fairly promptly.
Do you use a form?
At times, I have a form, which I hope is idiot-proofed, that just check boxes. That doesn't make me comfortable, frankly.
That the doctor's just checking
right.
boxes.
I would prefer to have something, preferably on the doctor's letterhead or the professional's letterhead, that shows this is not just some passerby, but somebody who has done the evaluation that needs to be made. And then I attach that to the petition that's filed. The petition is pretty straightforward with, certainly you and I write them with the minimum amount of gobbledygook. It's plain English. This person needs, for whatever the condition is, needs a guardian, and these were the people, generally the parents or the siblings, whoever, are the people who are willing to do it. There's not a cadre of people waiting to do this for an 18-year-old in Fairfax County or Alexandria or anywhere else. So that the family members are really the people logically to do this.
Well, let's talk a little bit about the petition and kind
Sure.
of break that down a little bit. I know that you guys do these all the time, but a lot of our viewers, understand how it works.
With quill pens and parchment.
Exactly. So key provisions. So the first thing, I guess, is we need the name and address
Right.
of the child.
Birth date. We do not need the social security number for the petition. We're trying to keep those more secure these days. We used to do that, but we don't anymore. We need to have it at the end of the process in court, but not for the petition. We need to let people know who are the other family members. This is particularly significant in the situation of divorced parents, where the non-custodial parent, to make this sound technical, the parent who's not raising the child directly, needs to know what's going on. Typically the siblings should know. That is, usually the adult siblings, the older siblings, should know what's going on with the younger child. And grandparents if they're involved in the child's life. But that's about it. It's not, you don't need to broadcast this across the universe. But at the same time, the people who get the petition will also see the report and the diagnosis. And that may be upsetting, that may be a surprise to certainly some of the relatives who just weren't aware of the extent of the diagnosis. So.
Sure. So one of the things that goes in the petition, of course, we have a multicultural community, so we identify what is the native language,
Yes.
and that can be important
Yes.
both for the hearing and
Right.
both for even the service by the guardian ad litem. Want to
Right.
talk a little bit about that?
You ought to be able to communicate with the person. And,
Sure.
And I've certainly been in a situation where what I don't want to do is have the parent translating for the child, because I'm not getting the objective sense of what's going on. I'm getting the parent's version, not the child's version. And
Sure.
not to say that parents mean ill for the child. That's why we're doing this, for the concern for the child. But still, it ought to be an objective sense rather than a derivative sense of what's going on here.
So there are programs with a lot of the courts to actually make interpreters available
Sure.
to both go out there when you were doing
Right.
the GL investigation, and then of course when they go to court to have someone there
And
as well.
and I've been involved with deaf interpreters where a deaf child or deaf parents, frankly, I'm not fluent in sign language, so I need to take someone with me to be able to translate. And I have had at least one situation, deaf and non-English speaking. So, there's a whole other layer of complication where we had to translate get it translated to English to the sign language. It just, you can conjure up all kinds of variations. If it's out there, we'll run into it.
The important thing is for folks to understand that just because English may not be their native language, there are tools and processes to make sure that everybody understands the process.
And this process is intended to be understandable. Yes, it's courts and it's formal, but it's supposed to be understandable. And it's not. I appreciate that Liz and I go to court frequently, and we know that it's not the reality that you see. The reality, rather, is not what you see on television. Mm-hmm. Nobody's yelling at anybody.
We hope not.
On television, judges are either crazy or silent, and the reality is somewhere in between. And the judges are going to be very considerate, very compassionate, because this is traumatic for everybody but the judge and the lawyers. The civilians. This is a big deal.
Sure. Well, I think the other thing, of course, we get the name and address of the petitioner.
Yes.
Gets put in the process. What about the backup guardian? Sometimes we see petitions that name a backup guardian. What's your thought about that, folks?
I don't do it. Do you do it?
I do it.
Yeah.
I do it.
You want to talk about what that's about?
So you can name somebody to step in, and that gives this backup person the authority to step in for 60 days until they get the guardianship filed for them to serve. And so it provides continuity. Mm-hmm. And I think for a lot of parents, when they're the sole caregiver for their child, it's really nice to know that you've got somebody set up and lined up for the death of the survivor of the two of them. So if they have a backup guardian, I put that in.
I think it's probably not a bad idea. Now, again, one of the things I see here as well is that we want to name these relatives, as you mentioned, mm-hmm. Ken, and their addresses so that we can contact. Now, the petition doesn't call for email addresses and phone numbers, but obviously that's the first place you would go to as a guardian ad litem to expedite the process.
Well, and in terms of what it is I need to prepare as representing the parents, I want to have all the contact information, as you say, the emails and the cell phone numbers and all that, because it's really to my benefit to be as forthcoming to the lawyer who's come, parachuting into this case, hasn't had the first idea what's going on. I want to be able to present everything in a simple way to, one email to the guardian ad litem saying, here's what you need to know about what's going on in this situation, and here are the people who don't speak English, and here, whatever the other, this child's at college, you need to know that, because college students don't have the same schedule that the rest of the world does.
Interesting. And I think that process about providing that detail is helpful as far as we start to talk about the legal fees associated with paying, which we'll talk about the guardian ad litem.
Sure.
Is make his or her job a little bit easier. Now you mentioned we don't file the Social Security number, don't mention that in the petition, but eventually we do deliver that. And also a lot of times the evaluation of the doctor is also delivered in a special way. Can you talk about that for a second?
Well, it ought not to be a matter of public access. Court files are public documents, and I can go look up any case I want to. Anybody can. It's not special to lawyers. In fact, in Fairfax, I believe you can do it. You don't even have to be to the courthouse. You can have access. You can pay for access without going to the courthouse.
That's right.
Which is just a little breathtaking. But at the same time, the Social Security number should be obscured, and frankly, the doctor's opinion or the medical professional's opinion ought to be inaccessible to the public. That's very private information. In fact, it's the most private information, the medical condition of an individual, some of which can be quite uncomplimentary. that is protected in the court system. I also want to make the point, we use the word Social Security, we use the concept of Social Security number. One does not need to be a citizen or be here legally to have a guardian appointed for them. So it is not, it's the suggestion that you have to have a Social Security number is not accurate. The legal system for this purpose doesn't care. We need somebody to be responsible for making decisions for this individual, regardless of immigration or any other status.
And that's important to bring out. Let's talk a little bit about the special notice that's going to be given to the respondent.
Right. There's the code of Virginia specifies that it has to be in big type. It has to be bigger than normal type. And it is, in a sense, a little bit frightening because it says you can lose all your rights and lose the right to make decisions about where you live and your own health care if you don't, and all this is going to happen at a specific date in the courthouse. And it's daunting. It is quite profound as to how much the individual who's going to have the guardian appointed for him or her, very serious stuff.
Well, it's like flashing lights.
Right.
You know, it's not flashing, but it flashes right out at you because of the fact that it's bold and extra large.
And it's comprehensive. Lose a lot of rights. I represented a man in Alexandria whose thing was to file for every candidacy that there was. And I became his guardian, and it turned out he was the reason that if you have a guardian, you can't run for office because he ran for every office in Alexandria, and people got tired of having him run for office. So my guy was personally responsible for that. So he gets a statute for himself. So.
Let's talk, lastly, let's talk a little bit about what's the role that the older siblings of the respondent often play in this whole process for guardianship for a special needs child. Liz, anything you want to share about that?
Well, oftentimes they're the backup guardian that the parents want to put so that they'll step in and help the child when mom and dad die.
And frequently they see themselves as sort of in waiting. You know, they're on the bench waiting to go in when the parents are not available anymore. And it's certainly a consciousness that they're aware of, that they have, that this is eventually going to come down to them to act as the substitute decision maker when mom and dad aren't able to do so.
Okay, well that's something to keep in mind as well. Well, we're running out of time for the first part of this show, but I wanted to give you guys an opportunity to share some closing comments about the first part of the show that you want to really stress for some of our listeners. So Ken, you want to go ahead and go first?
This is daunting in the abstract, that it seems like it's a big deal. In fact, it's a routine kind of thing in the court system. It is not it's not going to be Law and Order. It's not going to be with a full courtroom and lots of people staring at you and judges who are cranky. It's a process that works, that is effective and is treated humanely, so that we hope that at least by this kind of program to reassure that it's going to work out, really. We can make this happen.
Liz, how about yourself? Any things you want to share with our
a lot of people don't realize you can have co-guardians. You can have one guardian. You can have 3 guardians. I mean, there are possibilities, and a lot of people come in and they're shocked that both mom and dad can be the co-guardians for their special needs child. So it's doable.
Okay, well that's good to know. Well, I want to thank you guys for coming in to start this process with part 1 of this particular program. It's been very, very helpful and I'm sure very enlightening for our viewers, and thank you for this great public service.
Happy to do it.
You know, without a doubt, raising and caring for a special needs child is both challenging and rewarding. While you love your child dearly, as they turn 18, certain legal steps need to be taken so that you have the legal authority to continue to make medical, educational, housing, and employment decisions for them. Our show tonight touched on the challenges you can face as your special needs child becomes an adult, and the initial steps you need to take to start the process to become the court-appointed guardian of your child. This brings us to the conclusion of our show today on Guardianship of Special Needs Child, Part 1. Hope you found it informative. Replays of the show can be viewed on the Probate Nation website. Hope you also join us for part 2 of this show when our guests review the role and investigation and report of the court-appointed guardian ad litem, what to expect at the hearing, and what should go into the court order entered by the judge. Until then, on behalf of the Probate Nation, thank you for visiting with us.